Today in this video, we're going to talk about funding your trust. Hi, I'm Richard Barid, an estate planning attorney with Smith Barid LLC and one half of the Estate Planning Guys. So you've done the right thing. You've gone to your estate planning attorney. You've created a trust-based plan that is a revocable living trust, basically a container into which you can put your assets where you get to set the rules and define what happens with those assets and who's in control of those assets if you're incapacitated or when you pass away. A lot of people don't do is the second step, which is funding the trust. And it's really important. Let's talk a little bit about why. First, what does funding the trust mean? Funding the trust simply means taking your assets that are outside of the trust, most of them, and putting them into the trust. Now, there are some assets, especially certain qualified plans, IRAs, 401ks, 403bs, where we want to use, in most cases, beneficiary designations instead of transferring the whole asset into the trust. But for most everything else, we want to make sure it's in the trust. And one of the reasons for that is we can only avoid probate when you pass away for trust assets and assets with beneficiary designation. So if you don't put those assets in the trust and you pass away, someone's going to have to probate what's called your pour over will. If you're dealing with a trust attorney who knows what they're doing, they will have created for you a pour over will, which is a safety net. Catches all these assets you've left outside of the trust when you pass away and pours them over into the trust so everything goes according to the same cohesive plan. The problem with that, I mean, it's a good safety net to have, but the problem with that, or at least one of them, is you have to go through probate. At least in Georgia, and I believe in most states, depending on what county you're in, where you're living, and where you are, where your residence is when you pass away, probate may be a big deal or it may not. But in a lot of cases, it's at the very least a delay, a 4, 5, 6, 7 month delay before being able to distribute the assets. And the same is typically not true of a revocable living trust. The trustee gets control of that trust when you pass away fairly quickly and starts following the rules you've set up for distribution of assets. But one thing that's often overlooked, and another reason funding the trust is important, is the trust can be a great incapacity planning tool. And what that means is when you are incapacitated, either short-term or long-term, you've named someone in the trust, probably someone who you know, love, and trust, or maybe an institution that's very reputable. And once you've done that, when you're incapacitated, even if it's quite a long time, that trustee can step in and use the assets in the trust to take care of you and your family just the way you would do if you were able. So funding is not a difficult process, but it can be tedious. It's detail work. It requires some follow-up. That's why for all of our clients, when we're putting together a trust-based plan, we create some fairly detailed instructions on how to move all different sorts of assets from individual ownership into your trust. You don't lose control of them with a revocable living trust. You just would control them as yourself as trustee of the trust as opposed to yourself individually. And when you do that and fund the assets into the trust, you create this protection for yourself in case you're incapacitated, and protection for the people coming along behind so they don't get stuck with a complicated probate process. When you've passed away, if your assets are funded into the trust, it'll be much easier for those you're leaving behind. And that's one of the top things we hear when people come and talk to us about why they want to get their plan done. What is their goal? What do they want to accomplish? It's almost always, I want to make things easier for my kid. I want to make things easier for the loved ones who I'm going to leave behind one day. And a trust is a great mechanism for doing that. So once the trust is complete, you've had the signing ceremony or meeting in your lawyer's office, you got the whole plan, all the originals in your hand, everything looks great, then you start the funding. So things like a checking account, a savings account, CDs, money market, basic brokerage account, all those sorts of things should go from your name individually to the trust. And in addition to that, we're going to want to move real estate, and that can be certainly your residence, but rental real estate too. You can move that using deeds, and we would typically create those for our clients, those deeds that move the assets from them individually to them as trustee of the trust. And that way you have full control of the real estate assets, but you don't have to go through a probate process to get it once the person who put together the trust has passed away. So basic accounts, financial accounts, real estate, in addition to that, personal property. For a lot of people, they just say simply, oh, I'll split it up amongst my kids. But certainly there are situations where there are certain things you want to go to certain people. And if you want, so you want your trust to have control over your personal property, tangible stuff. So the furniture and the computer and the rug in the living room and the end table in the den, all those things, the law will typically allow you to create and sign what's called a general assignment. And that general assignment takes all these non-titled assets that are yours and takes them from you individually and puts them in control of you as trustee of your trust. So now when you designate things, it may be on a personal property memorandum that goes along with your trust, or the language may be in the trust itself. But when you're giving that property to the next generation, to items of tangible personal property, your trustee will be able to do that without having to go through probate, because those assets are owned by the trust. And now, once you pass away, they're in control of the trustee, and the trustee is obligated, has a fiduciary duty, in fact, the highest duty under the civil law you can have to another person, to carry out your wishes. Say your personal property, your knickknacks, your golf clubs, all those things go 50-50 amongst your kids, then that's what they do. But it gives you control instead of leaving that all up to chance. So when you create your revocable living trust, ask your attorney about funding your trust, and that you understand that's an important step. How are we going to accomplish it? And we found one of the best ways to put together a detailed set of instructions that tell our clients exactly how to do that. It doesn't have to be onerous, it just has to be done. Hope this is helpful. We'll see you next time. I hope you enjoyed that video. If you did, please click below to subscribe and hit the little bell so you'll get a notification every time we post some. Right now, we're posting about 3 videos a week with all kinds of useful estate planning information. So click right down here so you don't miss anything about estate planning, and click right here on your screen for the next relevant video.